Okay. Good morning, everybody. Thank you for attending our webinar today. And we are going to talk about building workforce in regional Australia and generally building overseas workforce in Australia. Mao, can you get the next slides, please? Yes. Very briefly, let me introduce myself and the company and briefly who we are and what we do. MB Migration has been established in 1998 under my management or under my migration license, and we have grown to a 30 employees little firm and doing very well in the migration industry. We're really changing people's life, not just overseas workers' life, but we're really changing our corporate clients' life. Our motto and why we are in business is really to showing a way forward to our clients. And also, sometimes it's very rewarding when the client calls us and says, hey, thank you so much for getting our visa or getting our sponsorship approved. You really changed our life. So this is really why we are in business. And we are in business for the last 27 years. And the business has grown to different areas as well. Can you have the next slide, Mao, please? As you can see, we have employment law, which is complementing migration law very well. We have commercial and property law as well. Next slide, Mao. Today, you know what will be our agenda. We are going to talk about labor agreement generally. We're going to talk about DAMA and what is the benefit of the DAMA. We're mainly focusing at the moment on DAMA in Queensland, skilled work pathways, or you know what you can do under the 482 regime, transitional temporary visa holders, how they can become permanent residents, and how you can attract and relocating talents to Australia. I think we're all facing a huge labor shortage in Australia at the moment. As you can see, there are some key statistics, you know, and what are the occupations, what are really in demand. I mean, mine deputy or environmental health officer, agricultural and horticultural, plant operators, workplace relation advisors. They are currently in a skill shortage in certain area. But beside that, there is a huge skill shortage in trade and different, say, for example, like hunting or engineering. We just have recently an interesting application for naval engineering. So the person was doing engineering work for submarines. So, you know, different occupations are still in high demand. Next one, Mel. Next, please. Okay. So first, I would like to talk about the different labor agreements, what's available. And I am not sure if you are all aware of what labor agreement is actually. And labor agreement has been developed out of the migration law. So the agreement doesn't follow really the law what prescribed in the Migration Act or regulation, which means that you can negotiate the terms with the Department of Immigration for your employees who you would like to recruit from overseas. This is very beneficial because sometimes you might have someone who is older and they won't fit under the migration regulation, maybe a different occupation that is not available for sponsorship. Maybe there is also someone who doesn't have relevant qualification or doesn't speak that good English. However, I always recommend to our clients that the employee should speak good English, because sometimes if they don't speak English, that can have adverse effect that they might not understand the instructions. I had an issue with one of the clients in the past where insurance claim was made against the employer because the employer did not understand the instructions correctly, and he chopped his finger off. Okay, so I think there are very important parameters what the employees need to meet, but the English is one of them. Okay, so what other categories we have under the labor agreement? We have company-specific labor agreement, we have industry-specific labor agreement, and we have the designated area labor agreement. So just very briefly, what is a company-specific labor agreement? It would allow companies to sponsor people under their own requirement. Okay, now there are differences between industry-specific labor agreement and company-specific labor agreement. What are the differences? Under a company-specific labor agreement, you can select occupations that are not on a skilled list. So, for example, industrial painter, okay, that is not on an occupation list. Therefore, you, as an employer, you cannot seek employing someone in this occupation. So you could seek that as a company-specific labor agreement, and you can employ the people under this occupation. The other occupation, for example, excavator operator or some construction workers. I mean, this is very topical because the Australian government is really supporting and pushing the building industry sponsorships. And for example, some of the building industry or construction workers are not on a skilled list. So labor agreement is very beneficial. Or in a mining industry, some occupations are not available, and the people can still be sponsored under a company-specific labor agreement. Now, as an employer, and I am an employer as well, you may don't like that the process of this to obtaining a labor agreement can be very lengthy. And that can be about 12 to 15 months. And also it has to be a conversation with the Australian, what you call the Australian Workers Union, with the union, okay? So sometimes our clients, they say, I really don't want to talk to the union. But it's not the client who is required to talk to the union. We can speak to the union on behalf of the client. But this is one of the two key aspects of the labor agreement, what sometimes holds the companies back to applying for. But we have done a number of that, and we communicated with the union. And even if the union is not approving the sponsorship or not suggesting that this should be approved, that is not affecting the decision-making of the department. But these are the two key elements, okay? The other elements of the company-specific labor agreement, that the occupation, as I said, the occupation has to be not on a skilled list. The company must provide a business case why it's important that you would like to employ these people or bring them into Australia. Sometimes, if you can't find two industrial spray painter, that can adversely affect your revenue, okay? Maybe work cannot be carried out because you don't have the right employees in that space. So this has to be presented to the department. You also require to undertake labor market testing, which I'm sure you are all aware of. What is the labor market testing? You must advertise the position for minimum 28 days, and it has to be not older than 4 months, okay? So if you do the labor agreement, you think, okay, I'm lodging this labor agreement in the next 2 months, so the labor market testing has to be done prior to that, but within the last 4 months. Some of the countries don't require labor market testing. So if the person is from a certain country, they don't require labor market testing, but under a labor agreement, you must undertake labor market testing. Further, you need to demonstrate, your workforce, how many Australian employees you have, how many overseas employees you have. And based on that, you can seek maybe 5 overseas employees in different occupation, okay? But maybe if you have only 10 or 15 employees, you may only able to nominate initially 2 or 3 overseas employees under the labor agreement. It is a terms of information that you shouldn't nominate more than 25% of your Australian workforce under the company-specific labor agreement. The other issue is, as I said, it can take between 12 to 15 months to get it approved. So if you know that your business is going to grow and would require certain candidates, then it's very important that you think ahead and you lodge this application with the department. You also can find on the department's website the already approved labor agreement, and you can have a look, what industries were approved and, why is that beneficial. Further, this agreement acts as a sponsorship. So once this agreement is in place, it is valid for 5 years. So you don't need to redo this. And during that 5 years, you will have an opportunity to have this agreement varied. Okay, maybe you initially applied for 2 occupations. Maybe you applied for varying, the age, but then you might find someone else in a different occupation that is still not on the skilled occupation list. And therefore, you say, okay, I would like to vary this and I would like to apply now for this occupation. Usually, as I said, you can seek concession for age, you can seek concession for English, and you can seek concession for salary. You're usually able to negotiate the salary by up to 10% below the TISMIT. So at the moment, the TISMIT which is the salary level, is around $73,500. And you can get maybe $7,300 off from that minimum salary. Depends what occupation we talk about, okay? So that's a salary concession. And also you can have concession if the person doesn't have qualification or doesn't have enough work experience. So that can be, that these attributes can be sought as a concession. But also is not recommended to seek more than 2 concessions in one application, okay? So that's just a thumbs up again, all right? So this is in a nutshell, okay, what the company-specific labor agreement entails. We have all the information, and if, some of you requires any detailed information list, what a labor agreement requires, then we can email you copies of that. But the main issue is, takes a long time. We need to have conversation with the union, and this is valid for 5 years, and we require a labor market testing. So this is in a nutshell, but this is not that simple, okay? So just, mentioning to you and really summarizing what the company-specific labor agreement is. Mao, next slide, please. Industry-specific labor agreements. This is listed on the department's website. And as I have seen some of our attendees from the HR space, from recruitment, these are the industry-specific areas where the companies can have a already prescribed industry-specific agreements. Now, as I can see, or you guys can see, unfortunately, the on-hire service has been missed from the list. It is also available. So there is a specific industry labor agreement called on-hire labor agreement. Just for your knowledge, I would like to mention that the on-hire labor agreement, where the recruitment company wishes to further on-hire the employees to the end user, the occupation must be on a temporary 482 skilled list. So it's not an occupation list. Okay, I want to bring in an industrial painter because that's what my client wants. It's not possible under the on hire. It has to be on a temporary skilled list. That's something which is very important for the on hire service. And also the on hire labor agreement requires the labor market testing and requires certain salary level. It's prescribed in the department information sheet. And also the visa can be granted in one hit, even if it's a temporary visa, can be granted for 4 years. Now, these days, all temporary visas can be granted for up to 4 years. So you can hang on to your employees up to 4 years. But until December, that was not available. It was only a 2-year period. But that's specifically stating in an on-hire service agreement. Then, as you can see, you have aged care provider. That's a specific labor agreement. We have done a number of that as well. That goes through pretty quickly because it's going through the aged care facility shall have a memorandum of understanding with the union. And once that is signed, then the labor agreement can be granted. There is also, for the meat industry, fishing, tourism and hospitality. And also the advertising space is also available. So probably it wouldn't fit on this page, but also for the advertising industry, a labor agreement or industry specific labor agreement is available. Hospitality is interesting because it's only available for the 5-star. Okay, so white tablecloth, bigger revenue. I think the minimum revenue is about $2 million, and how many chef is working there, but it's available for the 5-star. And then you can bring in waiters, waitresses, and not so highly skilled people that are on a skilled occupation list. So that is another industry specific labor agreement. Okay, next slide. Now we're going to talk about the DAMA. And I'm sure some of you have heard about this, and some of you may know that in Queensland, we have 2 areas of DAMA sponsorship, what is available. One is North Queensland, it's called FNQ, Far North Queensland DAMA, and also Townsville recently has been added to the availability under the DAMA labor agreement. The government, and I have some insight view on this, and insight information that Queensland would like to achieve all around DAMA opportunity, which means that they would like to have the whole Queensland to become a DAMA approval area. We believe that is maybe not possible because Brisbane would be also included in that. And I think that's not possible because we have a reasonable size workforce, and it's not like Adelaide, or it's not like Tasmania. Say Melbourne is not part of the DAMA, Sydney is not part of the DAMA, and also Brisbane it wouldn't be part of the DAMA. But all other areas of Queensland can be part of the DAMA approval, and application by the state is currently at the minister, but it's at the minister for the last 12 months. So, nothing is happening fast in Canberra, as we all know, but hopefully that's going to be implemented. So what DAMA means is designated area migration agreement, okay? And the local council has negotiated this agreement with the department. Now, Far North Queensland DAMA is run by a very knowledgeable person. I know him personally, and he used to work for about 25 years for the department, and mainly offshore. So he has a good understanding how the department works internally. So he's able to negotiate pretty good list of occupations, pretty good conditions under the FNQ DAMA for employers and for candidates. So I think, we are very lucky in that area if you have businesses in Far North Queensland. The other area is Townsville, and Townsville has a little bit more, maybe Townsville is a little bit more difficult because they want to see certain things. We've done a number of DAMA applications, and some of the application they said, oh, we want this, we want that. So it's a little bit more complicated than the FNQ, but it's all achievable and all can be granted. So what DAMA is all about, if one of you haven't heard about this, it's an agreement between the state or the local council and the department. And how it works is that first, the employer required to seek an endorsement from the local council. And the endorsement is like an application, just almost about the same as the company-specific labor agreement, but it's not 12 months. It can take a couple of weeks of the approval. So require a business presentation, why the business would require this overseas employees or employee, and also requires labor market testing, requires financial documentation, requires how many Australian employees the company has, and the work and the employee's residency would be in this area, okay, in the Far North Queensland area. As I said, the approval is about 2 to 3 weeks, okay? Once the endorsement is approved, with that endorsement, there is a labor agreement, it's so-called overarching labor agreement, can be lodged with the Department of Home Affairs. Once that labor agreement has been lodged with the department, the nomination of the employee can be lodged, and the visa application as well. So in fact, the DAMA process is a 4-step process, okay? Endorsement by the local council, labor agreement by the department, and once the endorsement is done, we haven't ever seen that the labor agreement is not approved, then nomination of the occupation as normal, okay, for any other temporary work visa or permanent work visa. And finally, the visa application. And again, the local approval body has the list of occupation, what they are using. They have the level of categories, what they are nominated in. So it means, for example, a horticultural worker who is not a high-level horticultural person maybe requires only 1 year work experience, so therefore they are in category 7. So they listed in that process what categories those occupations are, and the employer must nominate the occupation when they seeking the endorsement. Also, they can seek a number of occupations, number of positions, and that can be also varied because this is also valid for 5 years. Occupation time to time will change, but once the employee is under the original nominated occupation and they were approved under that occupation, that can carry on further during their employment. And if they and the employer would like to nominate them for permanent residency, that would be available for them under the same occupation. Mao, next slide, please. Okay. Now, we also have, the employer sponsorship, which is just your, excuse me, Mao, just 1 second, please. Okay, this is just what I have explained to you, okay? The employer sponsorship, the initially the endorsement, then the labor agreement, nomination, and the visa application. So I would like to have the next slide now, please. Okay, so the key benefits, and I already touched on this, what are the key benefits of each labor agreement and why this is a very good vehicle to hire overseas employees, and also the on-hire labor agreement for recruitment companies are a very, very good vehicle. Some of you maybe have one, some of you may be thinking of have one, but this is a very good vehicle, okay? So for example, secure long-term employees. It is extremely important that for certain occupation, I just hear every week, every day, okay, we can't find the people. We can't get people quickly on the job. So once you have these agreements, then you can employ overseas candidates. And all these agreements available onshore applicants, for onshore applicants and for offshore applicants, okay? So securing them and reducing the turnover of your workforce, because they have to work with you for 2, 3, or 4 years, depends what you are nominated them in. So this is something which is very important. Then you also can have a very dedicated labor force or very dedicated employee, because they are committed to you. Flexible workforce visa condition often allows workers to be deployed across different sites. So you can, for the under the sponsorship, you cannot change the occupation, okay? But you can change the location of the employees. So this is something which you also can utilize, that, you know, if you want to employ someone, long as it's not in a regional DAMA area, then a company-specific labor agreement, you can change the employee's location. Also under the temporary visa regime, under the 482, you can change the location of the employees. Some of our clients even ask, you know, if the person requires to travel overseas, how is that affecting their visa? There is also no effect on their visa, okay? Can be a cost-effective hiring if you're doing it yourself, okay, like if you're employing directly the employees from overseas. If the recruitment company finds you the employees from overseas, that also can be very effective, because you don't need to worry about, you know, your workforce and, hey, I don't have the right people, I cannot, you know, fill the position, and I am lacking of the work, I cannot produce the work, I am behind things. So I always say to our clients, when you endeavor to use these vehicles to engage overseas candidates, don't just look at what is your investment in this process. Always look at what it would cost you if you don't have this vehicle, or if you don't have this opportunity to employ overseas candidates. Myself, I am a business owner, and I'm employing a number of employees of mine, and I am absolutely delighted with their, commitment, with their quality of work. Just unbelievable. So I am extremely happy with this vehicle. And build a reliable global talent pipeline. All these candidates who you are employing in Australia can recommend your business to their local friends, local colleagues, you know, and you can have further recruitment pipeline from these current employees, you know, who you're employing on a sponsored visas. Next slide, please. And I just listed the obligation, which you all probably have from the department's website, and this information is also from the department's website. But really the key points are, okay, that the employee is receiving the relevant salary, okay, that the employees' superannuation has been paid, very, very important, that the employees are doing the same task what they have been nominated in, okay? And the other issue is what is important, that whatever you put in an employment contract, that's what you require to compliant with, okay? Then sometimes immigration can monitor the sponsors, and you would require to present records, okay, and the records mainly, you know, what is your pay slips? Have you paid everything correctly? Have you paid the superannuation? Is this employee required to work 50 hours instead of 38 hours? You know, so that's what immigration is looking, so there is no exploitation. Also, recovering some of the employees. So if you are paying for the visa applicant cost, that cost can be recovered from the employee, but just the visa application. So the visa application government fee and the visa application professional fee, if you're using a migration firm, that can be recovered from the employee, okay? Sometimes if there is a fallout with a sponsored employee and the employee leaves, then you can seek recovery of some of the SEF, what you have paid, and the SEF is a Skilling Australia Fund contribution that is required under the government fee when you lodge the application. But it's not like, you know, okay, I terminated the employment one and a half years and we still have 6 months and I would like to recover the 6 months SEF. You cannot do that. If over 12 months, you are in a second year, you won't be able to recover the SEF levy. It's always for the 1 year, always for the 12 months. The next 12 months hasn't started that, and there is a fallout, then you can recover the cost, okay, for that following year. And a very important thing what our clients usually ask, there is a repatriation cost, what immigration says. So if you have a fallout with the employee, then you are liable to buy a one-way ticket back to their home country if they leave Australia. But as you are all aware, employees can find another employer if their employment is terminated and they have 6 months. So if they staying here, you are not liable for any cost for them. Okay. I don't think there is anything in regards to that on the end. We have questions and answers, so you can ask me questions about the page. Next slide, please. Thank you so much. So just a recap of what is available under the regional sponsorship and DAMA. Now, I didn't really talk about the regional sponsorship, and I will mention that in a minute. So first, you know, as an employer, you can seek to sponsor people under the SID visa. Now it's called SID, previously it's called TSS, and previously called 457. So as a migration lawyer, we have to adapt all the time, okay? But I'm sure every industry has their own issues, you know, we need to keep adapting. So the skilled in demand visa have two categories. One is the core list and one is the specialist list. And just if I can mention this, that under the core list, the base salary is about $73,500 or $73,100, blah, blah, blah. But I just say $73,500. But under the special skills, the salary level at the moment is $135,000, and it will increase from 1st of July. The base salary under the core list, it's going to increase to 76,000 whatever, so I don't have the exact figure yet, and that will be from 1st of July. And I'm sure everybody is aware of what is the temporary 482 encompasses. You know, you have your standard business sponsorship, and once you have that, you can nominate the occupation, what is on a specific SID skilled list, okay? And also workers can apply for an SID visa through DAMA, or you can apply directly. Why is the SID DAMA is relevant? Because some occupation may be not on a list and they can do the temporary visa for 2 years, or the employer doesn't really, I rephrase this. The employer is not able to pay the $73,500 minimum salary plus super, because in that area where they are, maybe the salary is $68,000. So for those employers, it's very important that they can also use the DAMA under the 482. Okay, same rules applies as I explained previously. Then, we have the employer nomination scheme. Now, I find that sometimes our clients say, okay, they find this candidate, and that's usually relevant at a white collar, employment where overseas candidate would like to come to Australia under the permanent visa, because they believe that, hey, we're rooting our family out, and, I would like to have a security. Then there is a ENS 186 sponsorship available, which can be a direct entry application where the employee must demonstrate that they have minimum 3 years experience. But I'm sure if you're employing high-level candidates, that they should have experience, and also they should have a qualification, and their skills has to be assessed. But then they can be sponsored directly for permanent residency. Okay, so also it's available for a temporary transition. So if someone doesn't, you can't find a candidate who can pass level 6 English, but they pass level 5 English, and I'm talking about maybe, the Philippines or some Asian countries, but they are very good workers, then you can initially employ them under the temporary visa. And then after 2 years working with you, then they can transition to permanent. But sometimes you might say, I want to employ them for 3 or 4 years on a temporary visa because I can secure their employment, okay? Now, there is an interesting category, which is the subclass 494, which is a regional sponsored visa and has a separate occupation. And the separate occupation is on the ROL list, which is regional occupation list. And that's addition to the normal skilled occupation list. But the employer has to be in a regional area, and that's prescribed by postcodes. And the employee has to also reside in that regional area. And this visa requires, like as a permanent 186, requires a skills assessment and minimum 3 years experience in a position. And after 3 years, or actually the visa is granted for 5 years, but after 3 years, the visa applicant would be eligible for a subclass 191 visa, but has to be in a region. The employee must be continuously living in a regional area and work in a regional area. So that just shows how immigration really would like to support the regional migration where we can fill certain positions. The final availability, as I said, subclass 191, which is available after 3 years on the 494 visa. Next slide, please. Yes. So the challenges, I think I have explained all that throughout my presentation, because as I said, time, getting an approval for a labor agreement can be lengthy. You might find a candidate, and during the process, something happened to the candidate. They can have an accident, they can fall sick, so there are certain challenges, of course, but I still find very attractive for our clients to employing people from overseas. Now, what I know from in-house, that when you're employing people from the Philippines, and some of you may have experienced this, from the Philippines, the employees or the candidates who would come over to work here require a special release from the relevant, I think it's called overseas employment, can't remember the name right now, but there is a body in the Philippines which offers a approval that the candidates can leave the Philippines to work overseas. Why they have implemented that is because sometimes overseas employees can be exploited, And it's not just in Australia, but all around the world. So if they go into another country, if they go to the US or if they go to work in Europe, then they need to obtain this release from the overseas employment body in the Philippines. Okay. Next slide, please. Now, I think we come to the end of the presentation, and I would like to have question and answers and questions from you. And Mao, if you can moderate our questions and answers, I would be very delighted.
Hi, everyone. We have question from Joseph. Hi, Agnes. Are you able to provide the name of the individual from F&Q who started their Dhamma? Do they
Sorry,
work for?
what was the question? Sorry, just at the beginning, I didn't hear.
Are you able to provide the name of the individual from F&Q who started their Dhamma? Do they work for local council?
The name is Jeff, okay, and he is the one who is approving the Dharma in North Queensland. It's GEOFF. I think his family name is Heat, but I am not, it's not right in front of me, okay? So, but definitely Jeff, okay? Next question.
No question at the moment. If you have any question, you can unmute your mic and Agnes can hear you. Thank you.
Questions. Everybody understands what we have discussed or what I have explained, because we've had really no discussion. But I would be delighted to send you, first of all, the presentation. And if you have any requirements, like you would like to have some templates, we could send the information to you. And if you need any support, we are here to support you and serve you, okay? Mao?
Yes, thank you everyone. You can scan the QR code if you need a complimentary consultation, and we will respond to you shortly. Thank you.
Thank you, everybody, and hope you learned something today. Thank you very much. Thank you. Thank you, Joseph. Bye for now.